but my daughter.
Oh, hello.
Hello.
I feel lost way over here this far away from you.
I'm looking for a pen.
Kind of cold.
I got one. You want to use
All set, Suzanne.
Yeah, I'm looking for a pen.
pen?
I've got, I think.
Thank you.
Yeah.
Good evening. I'd like to call a meeting of November 5th, Zoning Board of Adjustments to order at 7 p.m. and introduce the voting members in attendance, which is myself, Suzanne Ryan, Vice Chair, sitting in for Ms. Klein, who has recused herself. Sarah Silk is the clerk. Chuck Sumner is a voting member. And Luke Frudenberg is a voting member. For alternates, we have Sabette Strawman, and I see Kate is absent, but I'm of the understanding that was planning on coming. I'd like to change the order of business on the agenda to...
Excuse me, Madam Chair, will you be appointing Sabette?
I will do that after.
Okay,
I got some housekeeping here first.
okay.
I'd like to change the order of the agenda as follows. The first item would be notice of decision, which takes no action. The second item would be rehearing request for Robert Beckworth. And the third item would be Roger Kent appeal of administrative decision. I have, for those of you who don't have it, I have a copy of the notice of decision. And I'd just like it recorded that the notice of decision is for the board's reference and was signed and recorded on 10/10/23. It was for the Brown case of October 2nd, 23, an administrative appeal, 16 Libby Street, Suite B, building permit revoked for duplex. And if we could have that attached to the minutes would be nice. Thank you. So the second item will be the rehearing for Robert Beckworth. Motion for rehearing of the Brown appeal of 10/2/23. And I'll appoint Sabette Strawman as voting member in place of Ms. Klein, who has recused herself. Are you all set, Sabette? Yep. Yeah? Okay. Since this motion for rehearing is solely a board decision, no public testimony will be taken. The board is charged with, under RSA 677:2 and 6773, Roman 2, appeal from zoning board decision, grants the board the opportunity to correct its own mistakes or actions that were unlawful or unreasonable. And so if you have that in front of you, which I'm going to pull it out now, I hope. Okay, let the record show that Kate arrived. Kate, I appointed Sabette for this portion of the meeting. What to do with it? Thank you. Thank you. All right, so the notice of decision, the motion for rehearing came in October 27th, 23, in a timely manner. The action of it states, the action of the Zoning Board of Adjustment was unlawful and unreasonable, and is respectfully requesting that the board grant a rehearing on this matter for the following reasons. And there are 3 items, although they're not numbered as such. The The first one is Town Regulation 17555. The second item is Suzanne Ryan, acting chair, should have recused herself from inserting her opinion at the planning board meeting on 6/20/23 on this project, stating should go for a duplex. Their third item is all the people appealing the permit were being coached by the ZBA chair, Audrey Klein. This includes neighbors Dennis and Marge Hart. Reasons 2 and 3, there is no substance of reason for rehearing per our attorney. That is 17555 is the petition shall set forth specific reasons and grounds which claim the order was this is the key words, the order was unreasonable or illegal or unjust. And did we apply unlawful or unreasonable decision when we made our final action? We have to either grant the rehearing, deny the rehearing, or suspend the order of decision of complaint of pending further consideration. So there's your three options. Discussion without going into a great deal of detail or lengthy discussion. You have three options. You grant the rehearing, you deny the rehearing, or basically you'd pending further information. I just need a motion.
I move we deny.
I need a second.
Second.
Roll call vote to deny the motion for rehearing. Luke?
Yes. Yes.
Sabette?
Yes.
Sarah?
Yes.
And myself, yes. Okay. So now, Sabette, you'll step down, and I'll put Kate on for the next item. All right, so the next one is public hearing for Mr. Kent, Robert Kent, 16 Libby Street, tax map 21713, case 08 AAD 23. Public hearing for appeal of administrative decision, the issuance of a building permit number 2023468 for the creation of a duplex based upon sections 17589 parentheses 2, 17591K, 175-128C parentheses 2, 175-129, 175-136, and 175-175 of the Wolfeboro Planning and Zoning Ordinance formal submission public hearing. And now, Sarah Clerk, would you give a little overview of the site visit that we did a couple of weeks ago?
Madam Chair, I gave it 2 weeks ago, and unfortunately, we don't have any minutes, so I'm not able to read that back to you.
Okay. Well, when we were there for the Beckworth.
I have my notes, I just don't have what I actually reported at the meeting.
Oh, just give your overview as you saw it.
Okay, but those present was Sabette, Suzanne, Kate, myself, and Luke, and also present were Brian Kent, Mr. Kent's son, Carolyn, I believe it's Chatier, I'm sorry if I'm mispronouncing that, Dennis Hart, Regina Brown, Eric Brown, Randy Walker, Mr. Beckwith, and Diane Bainton. And we looked at the property, and noted that it was the third property down the hill. Kent, it's the second. We looked at property lines, we looked at hearts, and we,
Pull your microphone down a little.
oh, I was just looking for the minutes from the last meeting. We don't have the minutes from the last meeting.
No
She
minutes.
was, yeah, heading those in.
Oh, sorry. Yeah. And we went over, looked at the church rectory and the garage at the rear, and observed Hart's drainage and retention wall and silt that was present. And there was information about work that had been done by the town in the past. And that's the best I can do because we have no minutes to report what I gave last time. I have this.
Thank you.
Oh, we're supposed to pass them on? Okay, sorry.
Okay, so in case I didn't open the continued hearing, I'm doing that at this time. We continued it on 10/2 in the late hours of the evening, so I'm not sure just where we left off. I know we took jurisdiction of it, but I also recognize that Luke had a question on the timeliness of the application, the Kent application, and I think you all got copies of council's read on that. And basically, if it's a case law, when the person knew, if the person knew, and when did he know, when did he find out. It's 30 days by our bylaws, but because a building permit that's been pulled is not advertised in the newspaper or a public hearing held for it, there are times that a person just doesn't know unless they happen to see the thing in the window for a building permit. And in this case, the party that's appealing is across the road, and an elderly gentleman, and I would presume that he didn't know in the 30 days. So we are within our jurisdiction of holding this hearing.
I'd like to vote on that. I would like to vote on that.
Oh, sure.
Because just for, you know, from why I brought that up is, you know, the applicant, we learned the last hearing that, something I didn't know, the applicant has to wait 30 days before they can commence with the start of construction. And that was something that was brought to our attention. So in the same sense, if the applicant has that burden to wait the 30 days just before they start construction, then somebody filing asking for to pull someone's building permit should also have to do it in the time frame that is in our rules. That would be my argument.
Okay, well, the attorney's opinion is the only exception to this is if the person appealing, Kent, can make a good argument that he wasn't aware of the building permit in time to file within 30 days. Building permit applications don't require notification to the abutters, so it's possible for a person to not become aware that their neighbor has gotten a building permit until the building activity actually begins, which may happen more than 30 days after the permit is issued. And you got copies of that? Mm-hmm. You still want to make the motion?
I do. I want to make a motion not to hear this.
Does anyone want to second that?
I'll second it for purposes of discussion.
For purposes of what?
Discussion, because I'd like to discuss the motion here. Did Mr. Kent have a reason why he didn't submit it within the 30 days?
Wasn't it short by 3 days? Or
It was
3
like
days?
31, 32
Yeah,
days,
so 1 or 2
something like
days.
that. Well, I've opened the hearing, so I would then call upon the representative for Mr. Kent to come forward and address the motion that's on the floor.
Hi,
Only
Audrey
that,
Klein.
only that at this time.
Audrey Klein for Roger Kent, speaking to the timeliness of the Kent appeal to the building permit. There's a number of reasons why this case is timely. I'm going to start with one that's lower on the list, but I think really kind of is telling, and that is building permits don't get noticed, as you understand. This building permit was submitted on June 26th, and it was approved on July 26th. And about halfway through that process, I emailed the Planning and Development Department and asked if there was a building permit on this property. And the answer was, I have no idea. So if I can ask the office and not be told, how am I supposed to know? 2, I did notify the office on the 30th day that an appeal would be coming, and that was by email on a Friday night because the information went out Friday afternoon at 3:35, and that was as close as I could get it, and turned it in the following Monday. So I believe that on Mr. Kent's behalf, I did everything a citizen could do to try to find out whether there was a building permit application being submitted. Questions?
Oh, can I clarify? Did you speak to an admin person? Is that who told you they had no idea?
I emailed Tavis Austin and asked specifically if there was a building permit submitted for this property. I do have copies of that email. Did I include that in your packet?
I don't remember.
Okay, I can get that for you.
What's the paperwork trail that's supposed to happen when a building permit is issued?
You would have to ask staff that. It depends on the department.
So, Tavis, how would a citizen know that a permit's been issued?
I just read you the legal interpretation. They said that you don't.
But if the planning office doesn't know, you said the planning office basically said, how would we know? We don't know. But somebody knows that they issued the permit.
The other question is, why wasn't my request researched and found out instead of just
I guess I'm
answered?
just trying to understand what
I don't know.
should happen.
Well, first of all, it's when did Mr. Kent know, not when
That's-
Audrey knew.
Well, as his representative, though, she was trying to find out, and she couldn't.
I couldn't tell Mr. Kent if I didn't have an answer.
So to answer the question, typically a building permit is turned into the administrative person, and then it goes to the building official. It then can get circulated to any number of departments as based on whatever the application is, and then it's returned to the building official who issues a permit. So I physically never see 99.9% of building permits.
Is it
So
there some
what-
kind of computer record or something? Did we not have a computerized where you can just pull up somebody's name?
Yeah, you can pull up the address, you can pull up the name, you can pull up all sorts of things. So when that was done, there was no permit in the system at the time, so I replied to Ms. Klein
Okay.
that I wasn't aware of a submitted building permit. But yes, there are instances where, it's not the second that a permit comes in that something gets entered into the computer.
Okay.
It's one of those things that's just a pure administrative paper shuffle, that it doesn't get posted right away, it doesn't go up on a bulletin board, it doesn't go on the website.
Right.
Well,
So
then-
for all practical purposes, when I was asking at the end of your last meeting if the board wanted to take jurisdiction, I had in my head the very thing that Suzanne was reading out loud. Because I know there are some board members that are going to say, well, it says 30 days right in the bylaws, and this is 32 days, so drop dead on delivery. And then the board accepted jurisdiction, so I'm not in the loop when you talk to your attorney, so I don't know when the communication is. I've never really gone by the 30 days because it's usually when the applicant is made aware or when the resident is made aware. So there's an entire email exchange between Audrey and I where I was like, yeah, I'm just probably going to be fine. Not worried about it.
Okay.
There's a couple other points. One, there was already activity going on in that lot, so that couldn't have been a trigger for a neighbor to know that a building permit had been applied for. There was already a building permit for a garage and activity on the lot that looked like buildings. So it's not like there was no activity, then all of a sudden a building permit went up and there was activity. There was no way to tell when that transition happened. If you want to go to case law, Dumas versus Somersworth, this is in the Laughlin, New Hampshire Practice Land Use and Planning and Zoning Guide, section 2110, Appeals to the Board, page 326, 4th edition. In Dumas versus Somersworth, Somersworth had a rule that appeals had to happen within 10 days. But Barry, the appealant, filed no written appeal within the 10 days of the date when the permit was granted. The board found, however, that he had protested to the building inspector as soon as it became apparent that construction was about to start, and that he had not been informed of the date of the permit or his right to appeal. The building inspector was clerk of the zoning board, and the evidence warranted a finding that Barry made his complaint within 10 days of the issuance of permit. Now, he just made a complaint to the office, essentially the same as the email that I made. Nevertheless, the Supreme Court allowed him, ruled in his favor because of that, not when he knew or should have known that the building permit was issued, issue that Suzanne Ryan brought up. That's the standard for appeals for building permits, within reason. Third, I do have a calendar with when I sent emails to the office, when I turned in paperwork, but since I thought that you had taken jurisdiction, I did not bring that part of the paperwork with me. However, I did email Tavis on Friday, which was the 30th day, that there would be an appeal coming, and Saturday, Sunday, and Monday I came in with, I emailed him the application and the permission slip from Roger Kent to speak on his behalf, and my argument, and on Wednesday I brought in a check. So that was the best I could do under those circumstances.
Okay, any other questions for Ms. Klein?
Does that change your mind?
It doesn't change my mind, simply because we asked the applicant to not do work for 30 days, and that became a real stickler in our discussion. And I understand that Audrey or the applicant's representative emailed Tavis, but I could say to Tavis, how many files has Audrey requested over the last year of building files? I mean, it's not like there hasn't been many files requested. It's not like she, in her statement now, she didn't say, hey, I have a problem with this building permit if it is issued. So the case law she just read was a case in which the person who was petitioning against it was obviously against it from the moment that they engaged it. I see that as asking the question, is there a building permit? There wasn't at the time. When the building permit comes in, it goes through every single office in town. It gets shuffled from the fire department to the police department to Parks and Rec for comment on some things. I mean, Conservation Commission, that paperwork gets shuffled all around town. It's not that town employees are inept in their ability to follow the process. It's a complicated process. It takes time, and then it gets entered into a system. And even then, you couldn't pull it up in the computer and say, what is the actual permit? You would need to pull the actual file, open the file, and then the permit would be in there. So it's a lot. But Tavis what were we going to say, Tavis?
I was going to say there's a big difference between asking for files. It was fairly clear from the emails that there was likely to be an appeal. I don't think it's worth going back to Superior Court to say, I'm very inclined to submit an appeal equals an appeal. But in this case, the appeal paperwork was submitted, 31, 32 days. So the only question I have for the board is there a substantive difference in hearing this appeal versus the last one that you just ratified?
Let me go back and read this again from the attorney. The only exception to this is if the person appealing, Kent, can make an argument that he wasn't aware of the building permit in time to file within the 30 days. And then the building permit applications don't require notification to abutters, so it's possible for a person to not become aware that their neighbor has gotten a building permit until the activity begins. So I think the question is, when did Kent know?
Well, I think given the complicated process that you talked about, then Kent filed as soon as they knew.
Yes, that's the question.
I think there's another question, too. I mean, let's say another petitioner came in on the same case and said, I want to have not to be, the horse is dead, okay? We're going to kill the horse again, what?
No, not necessarily. It might be a different horse of a different color.
It looks like the same horse to me, but, we can kill it again. But
Sarah had a question.
I did. No, I didn't have a question. I just was going to elaborate on something after what Sabette said. The fact that there had been a building permit out there for quite some time for a garage and all, when that got started, then to add into this the change of what the building was going to be was invisible to someone. They knew there was building going on, but how, unless you happen to be able to get a hold of those files or go to the planning office and ask about it, how would you know that a building permit given previously for garage and storage was now something totally different?
Right.
So I think that muddies the water of when he might have been, the person that filed might have been aware of a building permit, this additional building permit.
For the garage, but not aware that there was one for a conversion to a duplex.
Right, because there was activity already going on, and so how would you know that that activity was actually a different building permit? I think that would be hard to determine.
I think it sounds like a great opportunity for somebody to dig in and streamline this process.
That's for another day.
Because it would be hard for any applicant.
Oh, okay, so
We have a motion.
any
on the
other
floor.
questions on, I see your hand, but we can't, there's a motion on the floor, and I have to dispense with that. So I've got a second to not hear the case, in essence, is what you're saying. Any further questions? If not, could I have a roll call vote?
I'd like someone to read back the motion.
Oh, well, Luke, you want to restate your motion?
Luke Frudenberg made a motion not to take jurisdiction on this case that was seconded by Chuck for discussion.
For purposes of discussion, right.
Right.
Okay, you all set, Kate?
Yeah, I was just confused.
Microphone.
Microphone,
Kate.
Oh, sorry.
and speak loudly, I can't hear, I've got a head
Okay.
cold.
Is this Mr. Kent's?
Yes.
Okay, all right.
Okay, roll call vote. Those in favor of not rehearing would say
Not opening the Kent hearing.
not opening the hearing for Kent. If you're in favor of not hearing it, you would say yes. If you want to hear it, you'll say no. No, Ryan.
yes.
Not voting, right?
Oh, that's right, Sarah.
No.
I don't want to hear the case, so that's a yes?
Correct.
Yes.
No.
The noes have it 3-2. We will be hearing the case. So then I would ask the representative for the applicant to come up first, and then...
Madam Chair, I'm going to step down. I'm going to let Sabette hear this, because I'm going to, there's a hearing tomorrow night,
Okay.
planning board hearing, and I'm going to be there, so I want to step down, if that's okay. Will you take-
Thank you.
Okay.
I thought that was canceled.
And so then I'll appoint Sabette in
will have
place of Luke for this hearing. And I also wanted to ask my board members, since it was an issue raised by Mr. Beckworth, that I should have recused myself on the last hearing, his hearing. I would ask the board if they feel that I should step down, or can I act? I feel I can act impartially. If any board member wants me to step down, so be it, and make a motion to do so.
What was the attorney's opinion? What was the attorney's opinion about whether you should step down or not?
She said I wasn't necessary.
Okay.
I move you remain on the case.
Okay. Is everyone okay with that?
Okay.
Yeah,
Okay.
I'll second it, because if you have a question about recusal, you have to vote on it, so I'll second it.
Okay, so those in favor that I don't have to recuse myself signify by saying yes.
Yes.
Okay, thank you. I wanted to get that procedurally point out of the way so we don't run into that again. So we'll have Ms. Klein, who's the spokesperson for Mr. Kent, then we'll go to Mr. Beckworth, and then we'll open it up to the public.
Audrey Klein for Roger Kent. I would like to pass this out. This, for the most part, replaces the one that you had in your packet on the original hearing.
Thank you.
Will you speak up really loud when you're doing? Yeah, thanks.
Acoustics are tough.
Just have to get closer.
You don't have to say anything.
Thanks.
You don't have to talk. That's going to go in the file. I'll let the board decide.
Okay, in relation to the issuance of the building permit, I'm sorry, I'm pretty much just going to read through this.
Can you just lift that
More?
microphone a
Yep.
little bit?
Yeah,
Thank you.
thanks.
Yep.
Oh, that's better.
Sorry. In relation to the issuance of the building permit of 2023-468 dated 7/26/23 for a duplex dwelling at 16B Libby Street. Facts supporting my request to revoke the permit. I want to reaffirm, the board has already made a decision on 2 of the 3 points I'd like to make tonight. I'd like to have you reaffirm the revocation based on the size of the lot, which was decided last time. The single family, the size of the lot is too small to accommodate a new use as a duplex in the decision that you've made. Number 2, you decided that the definition of duplex the application did not meet the definition of duplex. I'd like you to reaffirm that decision in the revocation. Number 3 is the one I'd like you to spend more time discussing, because you were not very specific about the issues with regard to the drainage. In your findings of fact, you did state that Mr. Brown at the bottom of the hill did have some impact from work that went on the lot as far as water coming down the hill. But you did not attach that to any zoning code reference. So I'm going to walk you through why I think that you can and should do that. So Article 22 number 175, 128. This is page 2 of 4 at the top. The purpose and intent of Article 23 is that any use of land involving the arrival, departure, or storage of motor vehicles needs to be looked at to protect adjoining lots and the general public from nuisances and hazards, such as, number 2, accelerated runoff of surface water from land covered by impervious materials. I've put in the definition of impervious surfaces. This is the same definition that the state uses. It's also in Wolfeboro zoning, and that's any modified surface that cannot effectively absorb or infiltrate water. Examples include, are not limited to roofs, decks, patios, and paved gravel or crushed stone driveways, parking areas, and walkways, unless designed to effectively absorb or infiltrate water. The interesting thing about the Libby Street lots is that they were recently put from a residential district which allowed only 30% or 40% coverage and 10 or 20-foot setbacks to lot lines into the C1 district, which allows 100% coverage of impervious materials, and the setbacks are much smaller. So there's a responsibility now for those lots to account for their runoff. And I believe that these are what these sections are saying, these sections of the zoning. So section 17590, when additional impervious area is proposed to be provided in the C1 district, it must be in accordance with the provisions in this article. Nowhere in the article or the C1 district exempts review in the case of a single family or duplex dwelling parcels, which are allowed in the C1 district. It doesn't say just commercial or just for certain uses. It says when additional impervious area is created, it must follow this. So there's no code reason why they are not applying this to single family and duplex dwellings. And this review is supposed to happen at the time of building permit approval. And that is true whether it's the original garage or the other proposed ADU, or whether it's this duplex permit that we are talking about now. Any construction or development of a parcel that is allowed 100% lot coverage needs to show what they're going to do with their water. I did look at the GIS map, and there are several dozen parcels in the C1 district that have either single-family homes or duplexes on them that are as small or smaller than the Beckwith lot. All along Lerner Street, Glendon Street, Union Street, on the other side of the street down to the water, there's a couple of streets. There's a lot of parcels that this will impact. So my ask to you is three things. One is to reaffirm the revocation of the duplex building permit based on the first two sections that you already have spoken to. And A, make a finding that the application review under the code of 175-128, I'm on page 3 now, accelerated runoff from surface water from land covered by impervious materials applies to this building permit application on this parcel. And more broadly, make a finding that the zoning ordinance is to be read that review of plans to mitigate accelerated runoff of surface water from land covered by impervious materials applies to single-family and duplex parcels in the C1 zoning district, as all parcels in the zoning district are permitted to have 100% lot coverage of impervious materials. There is no exemption in these ordinances for parcels containing single-family or duplex development. I just said the zoning recognizes there are many streets that have single-family dwellings and duplexes. So this is not just a paper exercise, but can have critical impact to both public property, streets and sidewalks, and neighboring property. There's a reason that this is in the zoning. I would say that the site plan review, chapter 173, which covers site plan review and water runoff for all commercial projects in the C1 district, already covers the commercial projects. This section is specifically for those projects that don't have to go to site plan review, and that is single-family dwellings and duplexes. So I think it can be said that this 175, 128C really is focused on those properties. That's all my argument. To the extent that this impacts Roger Kent's properties, in the original hearing, before it was understood that there was no drainage plan for this property, and what was submitted is completely different than what was built, there wasn't a concern that any of this would impact the street side of the property. But looking at what is potentially proposed with draining out towards the street, that could impact both the public property and the front of Roger's garage doors, because they are slightly downhill and across the street. So drainage put out onto the street could impact Roger Kent's property, and that's why I'm bringing this up tonight. Questions?
I guess I'd ask you to restate the end of your testimony as to what you were anticipating the conclusion would be. I got reaffirm 2 sections of something, and then also 175, 128C.
Right. This is the top of page 3. I'm asking the board to reaffirm the revocation of the Beckwith Duplex Permit 2023-468, which are the 2 sections that it was revoked in your original decision. That's 175-89 parcel area and 175-175 duplex definition. Those were the 2 stated sections why that was revoked last time. So in addition, I would like you to make a finding that section 175-128C2, accelerated runoff of surface water from the land covered by impervious materials, was not, nothing was submitted to show how they were going to deal with that with the building permit application. And that's the time that that needs to be shown. So that the building permit application did not have that piece of paper in it, and therefore it wasn't reviewed. And then more broadly, I would like you to consider making a finding that the zoning ordinance is to be read that section 175-128C2 applies to all parcels in the C1 district, because they're all 100% coverage. Only the commercial ones go to site plan review. The residential and the duplex ones do not get covered by site plan review. Therefore, this is the section that looks at what are you going to do with your water when you cover this, completely with impervious material.
Okay.
Would you like me to restate it again, or are you good?
Thank you.
Okay. Other questions?
Okay, Mr. Beckwith, if anything you'd like to add?
I'm not sure. I'm pretty shocked that we're hearing this. She was late. You can't tell me the ZBA board chair doesn't know the permit was there? I talk to Roger Kent all the time. He knows exactly what my plan was, all the time. The only difference is that I was doing the storage because I was waiting to save money in order to do the apartment above. Roger knew that. So you're telling me that Audrey emailed him, didn't get the email back, didn't get the information back. She's in this town hall all the time looking up files. She knew. This shouldn't be heard. It should definitely not be heard.
Mr. Brown?
Thank you. Good evening. Derek Brown, 30 Libby Street. I'm going to start by addressing the last point made by Mr. Beckwith first. Many of you know, I'm going to say probably somewhat unfortunately, are familiar with my face from this summer. Having been following this from the planning board to the zoning board, I can tell you this permit was submitted. If you look back in the meeting minutes of June 20th for the planning board, the next day a permit was put in, an application was put in to change from a duplex, from an ADU to a duplex at the recommendation of Tavis. It was done at that meeting. It's on review. You can see it and you can read it. Nothing to do with Mrs. Klein. Now, secondly, in that, I hunted and asked about that permit all summer, what was happening. I only found out on the 27th or 26th of July, the day after it was signed, that it actually was submitted on the 21st of June. So I can tell you as an independent source, not even knowing Ms. Klein at that time, which I stated to Mr. Freudenberg at the last meeting we had in here when he asked me specifically of my dynamic or my relationship with Ms. Klein. I stated for the record, I did not know that person other than watching her at these meetings. So I did the same hunt during the summer trying to be aware of what was going on, kept in the dark. Now, as part of the address of, I heard something here tonight about, well, there was not work being done because the builder, in this case, Mr. Beckwith and company, were waiting for this next approval. Building was done all summer long. The hearts were here. We can attest to that. This has all been recorded, video and photographs. We know the work's been going on. So let's just put that issue behind us. Now, specifically, Article 175, 128. It is my opinion, and it is my opinion from photographs and from video, Mr. Beckwith is housing a commercial business in his new garage. He is manufacturing something to do with wood where he is also painting and staining. I've seen it. It's there. There's at least a minimum of one other employee, possibly two, maybe the second one's part-time, that's there daily during the work week. So if anybody else is looking for another reason for this to go from just a simple C1 zone to a commercial property that needs site review with formal stormwater runoff review, this is the plan. This is the program. This is the real estate for it. It needs to be addressed. That's all I've got to say. And if you want photographs, they are available on request. Thank you.
Mr. Beckworth.
Suzanne, you're the one that said they should go for a duplex.
Could you speak into the mic, please?
Suzanne Ryan is the one that initially said I should go for a duplex at the planning board meeting. That triggered my head, and I went to Tavis and asked him if that's something that's doable, and he said, absolutely, you're within your purview. That's what happened. Now, on October 4th, 2022, I received a building permit for a garage with storage. On 6/5/23, I applied for an ADU application advised by Terry, the administrative assistant. On 6/6/23, the planning board meeting was postponed due to a misprint in the newspaper. On 6/20, the planning board meeting was heard, and a motion was to approve contingent on putting a door in. Suzanne Ryan was at that meeting and said, I'm not sure why he should not be approved without a door, and I don't know why he doesn't do a duplex. Her words. So on 6/21, I applied for a duplex. On 6/22, I received a certificate of occupancy for the garage with storage above. On 6/23, I withdrew my application for the ADU, advised by Tavis and Jason to withdraw and apply for a duplex. On 7/11, the planning board mentioned On 7/11, the planning board mentioned our withdrawal of the ADU application at the meeting. On 7/26, received building permit for a duplex. On 8/20, Mr. Brown filed an appeal. On 8/22, a disagreement with Marge and Dennis Hart on Libby Street where they were supposed to they wanted to install trees on my property to do a screening. And I was at first for it, and then I saw how much property they were going to eat up. And as you folks know, I don't have a lot of property there. And so I had to say no. He was super upset.
I'm sorry, who wanted to install trees?
My next door neighbor, Dennis and Marge Hart. They're down the hill from me.
Okay.
On the right-hand side.
Right.
So on 7/26, I received a permit for the duplex. On 8/20, Mr. Brown filed for an appeal. On 9/11, site visit to the property, my property, and I was not notified of, but you did a site review on that day. On 9/11, you had the meeting, which I was not prepared to go to and couldn't make it. On 9/25, the ZBA meeting was continued. On 9/25, the ZBA was continued again to go for outside counsel. This is actually comical, and I'm not even halfway through. On 10/2, the ZBA denied my application for a building permit for a duplex. On 10/3, I spoke with Jim Pinio. On 10/4, spoke with Tavis about continuing my landscaping for the building permit that I originally had, which was a garage with storage above. They applied that I could, but said that I shouldn't do it because it's just going to cause a ruckus in the neighborhood if I could hold off until the meeting was over. On 10/12, I reapplied for an ADU permit and will go in front of the planning board on November 7th. That's tomorrow. On 10/27, I filed for appeal for the ZBA to deny the decision to deny the duplex. On 10/30, I received a notice to the abutters to the public hearing notice on the 7th, which notes an error on it. So now my planning board meeting for tomorrow is now 2 weeks away. Yeah. This is great. I can't even do this. This is the saddest thing I've ever been through in my life. I cannot believe I have to go through this. And to have the ZBA chair think that she didn't know about the building permit, that's just not, it's not true. It's just not true.
Mr. Beckwith.
This is insane. It really is.
I really understand your frustration. I mean, the same kind of frustration came up with Mr. Brown last time. I mean, it's kind of a comedy of errors, although it's not funny. But I think the point is not that Audrey did something wrong, it's that the communications throughout this or the adherence to what the expectations are. When you changed from an ADU to a duplex, there are certain things you have to do. Those weren't done, and that's what we are here to. That's the only thing we can really address. I mean, that's.
Well, you shouldn't even be hearing this case. She was over 30 days late.
But if.
But what?
Well, I'm not going to.
That's another frustration. I mean, you could do something about that.
Well, I think the town needs to look at how they are tracking from the time a building permit is issued as it goes through different departments, so that I'm sure Tavis didn't mean to give no information to Audrey. He told her what he knew. But based on what everybody knew at the time that these things happened, they acted in good faith, I think. So I understand it's been incredibly frustrating.
I'm going to email this out to everybody so everybody has a nice little copy of what you guys put me through so far, okay? I'll probably put it in the paper, too. I mean, people need to know what's going on here. You just don't know what you're doing. You just don't. And you don't even let Travis speak, and he's the expert. He went to school for it.
Madam Chair.
She wants.
Oh, I'm sorry.
Okay. I would also just like to add in that the ZBA is not responsible for mistakes that staff makes, so things such as planning board meetings being
I'm not blaming you, ma'am.
stuff,
I'm not blaming
we
you.
have
I'm
no
just-
control over that.
You just need to know that you are hearing a case that was late. So you were part of it. All you had to do is say, sorry, you're over 30 days late. She's the ZBA chair. She knows what's going on. And you guys look ridiculous right now because you're hearing it with the ZBA chair. And it's late. Don't you look a little biased? It looks like it to me.
Actually, Mr. Beckwith, we are following advice of our attorney.
I'm sure you are.
So, and I don't think.
And how come you don't let Tavis speak on his behalf?
Well, quite frankly, it's an administrative decision, and he's involved in it, so it'd be a conflict of interest for him to talk from...
They're appealing his decision.
Excuse me, I have the floor. Okay? His opinion is being appealed. If he would like to come out and address something from the podium, he may, as can anybody from the public at our meeting.
Okay. But you won't let him speak from the chair there.
Excuse me. We've been advised by counsel that because this stems from Tavis's department, an error in his department, that he is not supposed to be testifying as the town planner. Now, if he wants to get up and testify from the podium about what happened, I suppose he can, but this appeal is about what transpired from his department. He's the head of the department. His building code enforcement officer has made an error, as we decided on the first application.
Mm-hmm.
So he's in the position of, it's hard for him to be able to testify in your behalf because this is about his department.
Well, it
So,
would be...
so, as I said to Mr. Brown at one of his hearings, don't take it out on us. We're not the ones that created the problem.
I guess what I'm thinking about is that he approved the permit, okay, and he approved it for a reason, okay. He had a reason, and you didn't let him explain it at all.
I don't believe he ever told him that he could not speak.
She did a couple of times.
A couple times.
Well, not
At least
from
one
that
of-
position. You can't speak from the table.
I love the semantics of who's sitting where and speaking. I'm not a resident of Wolfeboro, and I'm not, so what am I? I'm either speaking from there as the person that made the decision, or from here as the person that made the decision. I think the clear thing is I'm not guiding the planning or the zoning board on how to proceed with an application.
If someone recuses themselves or has a conflict, they're supposed to step away from the table. As Luke just did, he felt like he had a reason to recuse himself, and he properly did that.
He's a board member. There's a big difference.
Oh. Luke,
Luke Freudenberg, I believe it was in our last deliberations, and I just wanted to bring it up for a point, because what Audrey's asking for that third point, I believe our town, it's just in the minutes too, but our town council urged us not to add in anything about drainage into our decision in the last case. And I would just ask you guys to look at the notes of that before you add something like that. And I think that was one of the things that was specifically said, that we weren't going to go there with that. So I would just ask that you read your minutes before on that. And when Tavis, from my recollection, when Tavis signed that form, he signed it as on behalf of the town of Wolfeboro. So acting as planning director, he signed that form as the town of Wolfeboro. So that is a distinction that everyone needs to know. He's an employee of the town, acting on behalf of the town. So when he signed the application for the duplex, he was signing it on behalf of the town of Wolfeboro. That's an important thing to remember, because that's Mr. Beckwith's major argument, is that he did nothing wrong. You know, he came, followed the procedure, went to the town issued these amount of permits, and then there was an appeal. And that's where we are here. So I just want to remind you of those facts.
Yeah, thank you.
Thank you.
Any other public comment?
Good evening, once again, Derek Brown, 30 Libby Street. There's one other item I did not get to read from that I just wanted to share with the board, and it was in reference to my earlier comments of the commercial building business going on in the C1 district, which triggers automatic site plan review, drainage, stormwater runoff plans, which for the last meeting that we were all at, we had a proposed possible plan for drainage presented by Mr. Walker on behalf of Mr. Beckwith. We've seen nothing of that implementation-wise, okay? Nor documentation stating that that is also part of a proposed future of making this problem go away of drainage. But I had a meeting with Mr. Pinio. He had reached out. I had asked him if there's anything on behalf of our property at 30 Libby Street that I could give him further info. And I was referring to the letter I received from the board acknowledging the revoking of the permit decision from my appeal. And I got the following email from Mr. Pinio, town manager. It is my understanding that the findings of facts were used to support the decision. He's talking about the 3 items that were in what Audrey was talking about. The first 2 were very clear, but there was also an acknowledgement of drainage-related issues, water-related runoff issues from the property, but it was not formally stated as Article 175, 128, which is really what we're saying. It's time to step up and say it is what it is. Okay? So Jim goes on to say, as I expressed my concerns to him, is it is what they intended, what they meant, but he was living on or hiding behind well, they didn't state that article, so it's not a problem. That was the mindset I'm dealing with here. Forgetting everybody else in this room, that's the mindset I'm dealing with, which is my equal frustration. In this case, it might be the one thing I share with Mr. Beckwith, the frustration of the ambiguity of things in the town building department. Okay, so he goes on to state, it is my understanding that within the C1 district, a property can have 100% impervious surfaces. That's true, it can, which is the whole reason for this argument. Somebody has to be responsible for the water they create on their small property when you're talking about plans for properties that abut one another with virtually 0 setbacks and the ability to pave the entire surface. Okay. Question? Sure.
No, I'm trying to get the chair's attention.
Okay.
You'd like to say something?
I'd like to read something.
Go ahead.
This is September 20th, 2023, from Christine Johnson. C, erosion and drainage impact. Mr. Brown is alleging that Section 175-128 requires the application for this building permit to include a stormwater management plan, and he points to Section 173-21 stormwater regulations in the ordinance as the provisions that should have been required. In other words, he is challenging the administrative official's interpretation and application of the general requirements in Section 175-128. Mr. Brown believes the administrative official should have interpreted Section 175-128 as requiring stormwater management information for this particular project because it has the potential to create runoff, and therefore he seems to argue that the administrative official should have required compliance with the provisions of Section 173, and the decision that neither of those things applied to this project was incorrect. This is a question the ZBA likely does have the authority to answer because it involves the application and interpretations of specific zoning ordinance provisions in the building permit application.
Okay.
So clearly, it was something that we could address in the administrative decision.
Sabette?
Can I make an attempt to just make sure I understand this, or to try to bring us back to focus here a little bit? Number one, we don't need to continue talking about whether we should or should not have decided to hear the case, because we've made that decision.
Decision's
We've
done.
made that decision. Number two, Mr. Kent's appeal is different than Mr. Brown's. So
Yes.
even the conversation about the drainage and the relevance of that in Mr. Brown's appeal does not relate to this appeal, because in Mr. Kent's appeal, it was clearly stated as part of his appeal, correct? So we just deal with it as part of this appeal, put Mr. Brown's over there. And number three,
Well, hold on. Mr. Brown's appeal is done.
right, it's
Yeah,
done.
correct.
So whatever the argument is about whether it should or should not is not relevant. We're here to hear Mr. Kent's appeal.
Except that when we do go into deliberations, we will be addressing specifically,
That is Kent's.
Right, so we can, we
What-
talk about it, but it's relative to Kent, not relative to whether or not. we should
Understood.
approve.
hold on.
Understood.
Hold on, you two. Wait a minute, one at a time. If I may finish. When we go into deliberations, we take this application from Mr. Kent,
Right.
and we address those items. Those, I believe, are 6 items.
And drainage is part of his.
We do not get into new items that are brought up.
Right.
Agreed.
Well, and that's what I was also going to say. This new information that Mr. Brown has brought to us about the commercial, what's going on in the garage, is, I don't think, relevant.
It's not relevant.
Can I
So
comment
we
on
need
that
to
one
put that
comment? Can I make an observation on that comment? Because I understand, okay? This has to do with not my property. It has to do with if drainage is not implemented, it will directly affect Roger Kent's property. That water right now has got to go somewhere. If you do not create a place for it to go, it's going elsewhere.
That isn't what she was saying. She was saying relevant to the new information you gave about the commercial use of the first floor of the garage is irrelevant tonight
Okay,
to us.
all right.
If you have an issue with that, as I've said before, you go to the planning department
Yeah.
and you go to Mr. Pinio for enforcement. We do not enforce.
Understood.
Okay. Sabette, did you want to continue?
No, those were, I just wanted to clarify those 3 points.
Okay.
Thank you.
I see over here Audrey. Ms. Klein, you'd like to have a last word?
Audrey Klein for Roger Kent. I think the comedy of errors is a good description, although this is not funny. But a lot of this is not relevant to tonight. But a building permit application was put forward for a garage, and then a building permit was sent, or the application for the ADU was sent to the planning board. The planning board correctly determined that it didn't meet the requirements. That's not any neighbor's fault. It's really the applicant's fault for not submitting a proper application. The application for a duplex came before the board. The board rejected it. It wasn't a complete it didn't meet the requirements of a duplex. There's a lot of errors with noticing. It's just it's a mess, basically. But I can say it's not because of Audrey Klein.
No.
Anybody else? Last chance. Okay, then I'll close the public hearing portion. And we'll go into deliberations, at which time we will not take any further comment from the public. So I draw your attention, the board's attention, to the application dated August 30th, 23. And it starts on page 3. What I've tried to do with the handout that Ms. Klein just gave us is cross-reference what she was reading from and what she actually submitted. Anything that she was reading from that is not on the application, we will not address. That's off the table. So I would ask your assistance in taking the two documents side by side. I've done that. I found one that doesn't apply, but I need more than my eyes on this. But cross off or check mark the ones that apply from the application. This is all we're going to talk about, what's on the application. What's in her handout that's not in the application? I found one item. Does anybody find anything else? I'll give you a few minutes. And that will be using the code ordinance numbers.
No.
Which handout?
No. The handout that says appeal from
Got
administrative
it.
decision. That's what
This
Artie
one,
gave us.
it's got
And then
the,
the application has in magic marker up at the top 08 AAD-23 on it.
Kate, this,
I have it.
this, and then what she just gave us,
Yep.
if you would.
And right now, we're just discussing 17589.
We're not discussing anything yet. I'm looking for what has not,
70.
what
What's
is
not?
not on the application
Oops,
that
sorry.
she gave us tonight that's on her handout. So you start with page 3, 17589. That's on her handout. It's the first item. I encircled it as number 1. On her application, 17591K, is that in her handout? It's on page 4. I entitled that number 2. 175-128C2.
8C2. That's on the top of page 2 in our handout.
That's on page 2.
Yes.
I numbered that number 3.
Number 3.
Because I'm going to be using this application and not this handout. 175-129.
Bottom of page 2 on our handout.
That's number 4. 175-136.
That's on page 4, number 2. That's the second one. Off-street parking requirements? Yes, page 4.
All right. That's number 5. And the last one on her application is 175-175,
Page 4.
and that is on her handout.
So did you say you saw that there wasn't?
Wait a minute, what? What?
Never mind.
So, what is, wait a minute. All right, what didn't make it on her application, I believe, is only one item, which is 17590.
Page 2, setback requirements.
It's on the handout on page 2. Can anyone find it on her application? I don't believe so.
No.
Then we will not be discussing that. Cross it off. All right. So now, Let's start from the beginning of the application. And you're welcome to use the handout as a cross-reference if the description or more detail than what's on the application. So we'd start with 175-89-2. Sarah?
Okay, that was already been determined.
Yes.
I move that we reaffirm that.
Second.
Roll call vote for reaffirmation of 175-89-2. Ryan, yes.
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 What's the question?
Reaffirming our finding from the last
Oh, yes, of course.
Okay.
on the first point.
Yes.
I'm wondering if our secretary is able to follow. Okay? Yeah, thank you. The next one is 175-91K, conversion of a permitted use to another permitted use, and no change to the exterior of the building or parking is required. I don't believe that was on the other one.
It wasn't.
No. All right. So we'll have to make a determination on 175-91K. Where's my,
So are we saying, was there a change to the exterior of the building, or are we addressing the parking?
well, there wasn't change to the exterior of the building. They added a stairwell.
I thought they added a deck as well.
What?
I thought there was a deck that was added as well.
I think originally the property had some sort of a platform and, what was it, some kind of a trailer or something parked there? But the garage has had a stairway added on the exterior back of the building.
Right.
No? Tavis is shaking his no.
How are they going to enter then?
When we went to the site visit, did
Yeah.
anyone see a stairway on the back of the building?
I feel like there was, you had to enter, yes, there was a front deck that was added because we had to go up steps. There was a landing, and then from that landing, we went into the living room area, and the kitchen was directly in front of us. So there was something added, right, Tavis? I mean, we're at a disadvantage because we did not do, okay, well, I thought you asked him earlier.
No, this is a deliberation between
Okay.
us. You asked
Well,
your
between
board
us,
members.
I remember that's the way we went, and there was a deck, although we did not do a site visit this time. So we're working from last month's memory.
There was a stairway added on the back of the garage.
You had to get to it from outside and upstairs.
The back of, through the church parking lot,
Right,
in the back of the building?
yes.
Okay, so there is a change to the exterior of the building, and therefore additional parking requirements apply. The original building permit for a garage with storage above had not received a certificate of occupancy. Therefore, this is or was not an existing building at the time of the application for the permit.
So Suzanne, does this mean that when it says "or parking is required," that means that off-street parking, it has to be dedicated dedicated
Right,
parking
I think
spaces?
it's 2 spaces for a duplex,
Right.
and I think that would be an increase from 2 to 4,
We did
at least 3.
We did get something from Mr. Beckwith that had a parking plan, I think during the course of the meeting, that had a space for 2 cars to park, I believe.
Well, the question is, do we agree that there was an exterior change? And I think we do.
There was.
But then we agree that because of that change, that the building that parking is now required from that change and that use?
And we also have to remember that we're talking about whether this parking thing was given to the code enforcement officer when they were getting ready to give out this building permit.
Right, and it appears there was
It
not.
appears it was not, because it was none in the file.
Right.
Okay, so then we would say, once, follow me, I'm not speaking for you all, but it seems like we would say that 17591K was mistakenly overlooked by the building department as a requirement.
So you're saying that the inspector overlooked it, but is there 2 parking spaces there or not?
They need,
It wasn't submitted with the application.
It's irrelevant of what exists today.
It just wasn't on the application?
Right.
Okay.
Right.
It wasn't part of it. We got it during the meeting, but not during the course of the application.
The snapshot in time is when the code enforcement officer made his decision.
So,
We're going on to number 3?
well, should we vote on that and bring that to closure? Like whether we agree with
you can do it
upholding
one
that?
by one if you want. I need a motion that, where am I? Oh, I'm looking at the
We
wrong.
uphold Kent's appeal.
I'm looking at the wrong.
On 17591K.
A motion for 17591K conversion and exterior change requires parking, and that it was not addressed by the building department.
Is that your motion, Svet?
Yes.
I'll second that.
Okay, I have a motion and a second. All those in favor, roll call vote. Ryan, yes. Sabet, yes.
Yes.
Silk, yes. Chuck, yes.
Yes.
Kate, yes. All right, so we've got those 2 done, 1 and 2. Number 3 is 175-128C, accelerated runoff of surface water from land covered by impervious materials. I know at our last discussion, I was reluctant to delve into that water runoff issue. I think it was aptly described by Attorney Walker about the water coming from that area in general. And although Mr. Beckworth's removal of contours and soils, it certainly exacerbated the problem. Beyond that, I don't know what to say to you. You guys are going to have to start making some decisions. 175, 128C.
Is there a C2? I can't find C2 in my copy.
It's right here. Accelerated runoff of surface water from land covered by impervious materials.
Where is that? It's not in my copy.
Page 3, look at Audrey's,
Do you have the latest one?
I don't know.
Okay. Maybe you don't have the latest one.
wait, I'll look it up. 175.
I'm not comfortable addressing
Well,
that. as-
so you were here at some of our meetings regarding this. and-
Sarah, use the microphone.
Oh, I was just saying to Chuck that he was not present all of them, but it was noted that the printed copy and the online copy of the zoning ordinance does not always say the same thing,
Okay.
which also confuses things.
Well, the reason I'm asking is because 175, 128C is all I have, and it just talks about driveways. It doesn't talk about the entire lot, the way I read it.
Yeah, I suppose.
But regardless of that technical detail, I agree with you that it's really not within our expertise to be able to say where the water's coming from and where it's going.
We don't have, and again, Attorney Walker made this point, we don't have an engineered plan or
Right.
statement that says that Beckworth's property is the sole purpose of the flooding in that area. So I think it's inappropriate for us to go down that road.
I have it here. If we don't have the information today, they certainly didn't have the information when they were issuing the building permit.
Well, I would make a motion that whereas we do not have the evidence that supports 175, 128C2, that Beckworth's property accelerates the runoff, that we not address that as a deficiency.
But we, in our findings of fact, in our last meeting, we said there's evidence that Mr. Brown's property is affected by water runoff and drainage that is caused at least in part by activity and development on the subject property.
And that still holds true, that I'm still saying the same thing. He exasperates the problem, but it is not the problem, as we do not have any facts that support that that is the problem. We don't have an engineer's drawing. We don't have an engineer's statement. We have lay people's statements. And if you notice, when we did the reasons for revoking the permit, we did not include that.
Right, that's true.
And so I'm suggesting that we do not include it again.
And is the difference that in Mr. Kent's appeal, he's calling it accelerated runoff versus in our findings of fact, we said there's evidence that it's affected by water rain, but that is at least in part by activity. It sounds a lot more.
We can still say the same thing, but I feel strongly that we do not make it one of the reasons that the building department was deficient in issuing the building permit.
Okay.
I'd feel more comfortable saying that we don't have a report and there was no report when the building official got the application. It was missing, it was incomplete. It's still missing.
So I would move that we deny this particular point on the basis that we don't have enough technical, complete information to make a decision on it.
I'll second that.
Okay, you want to, did you hear that up back? Did you get that? Okay. All right, so we're not going to include 175, 128C2 as a deficiency of the building department.
Right, you have to vote on it, though.
Yes.
That's basically what your motion was?
Correct.
Okay.
Could we wait one second? What did you show him where you found it in writing somewhere?
In my book.
I'm looking in my book. I don't.
Well, honey, I can't help it.
My book is as old as yours.
Okay.
Mine says April 22, I think, on it.
Because I don't have a
What is it,
C2. I'm with
175,
Chuck. I don't have a
128?
C2.
Okay. Okay, here I am. Well, maybe it was a new page after the book came out, because things are voted on in March or something. Anyway, it's right here. C, protect adjoining lots and general public from nuisance and hazards such as, 1, noise, glare, headlights, blah, blah, blah. And number 2 is accelerated runoff of surface water from land covered by impervious materials.
And do we know when that was added? Was it added prior amendment 5?
I don't know. I don't see anything that says when it was changed.
Well, it would have been amended as of March at the
It had
most
to-
recent would have been March.
No,
which
nothing
would-
passed last March.
Oh, that's right, everything just was.
All right, hold on, let's get back to the business at hand here.
Okay, I'm just trying to determine, though.
All
whether
right,
that's
here, now let's go
applicable.
back, here's, we've got attorney's advice. Things that we can weigh in on and things that we cannot.
And I read that thing from September 20th where it says erosion and drainage
Well,
impact.
Wait a minute. It's specific to the application. Again, going back to the cited criteria.
And we determined there was no report.
The applicant, in this case Kent, claims that 175, 128C2 was not addressed by the building department. Our previous application did address that. Oh, no, did not. So we didn't have historical decisions or lack of action regarding drainage. So basically, that's what we're saying now. We don't have the documentation that supports the problem. And Chuck has made a motion to not include this as one of the reasons why we do or do not support the application.
But is the question, should the building department have done something should have been done as part of the building permit to ensure that there was a review about drainage? Yes. That's what I'm trying to get a handle on.
Well, that's what this whole thing is about.
I know.
That's what this whole application is about.
No, it's
what
about
the
more than
building
drainage.
department didn't do
Right.
in the issuance of the permit for the duplex, not the garage, the duplex.
So my motion was to not rule on this because of lack of information.
And you got a second.
Yes.
I think Sarah seconded it.
Yes.
Okay. I want to withdraw my second because I thought your motion was that the report wasn't there, not provided, so therefore the code enforcement officer could not have ruled on it. We still don't have a report.
No, we don't. So I was
So
saying,
he could not, at the time of the building permit, there was none, and now there is none, so it wasn't provided, correct? Okay.
still, so how would you suggest we move
How
this?
would you frame it?
I would say that the code enforcement department erred because this report was not available with the application. And it should have been, according to 175, 128, C2.
Well, let's have a call on this. Your motion still stands, Chuck?
No, I would do my second,
Well, I'll give him a second.
okay?
Do you want to still leave your motion on the floor, Chuck?
I'm just trying to decide how we frame our answers, irrespective of what the code enforcement officer did or did not do.
Okay, so Kent is saying that there was an error because this wasn't addressed. And I thought you were trying to convey a motion that said that this was an error. It wasn't addressed.
Can I ask about a question about process? So are we saying that when someone applies for a building permit, the code enforcement officer, before giving a permit, there would be some kind of report or review about drainage? Before giving it to you?
Sabette, this whole application is about what was not done by the building department
I
to
understand.
be able to issue the building permit for a duplex.
And I'm asking what the process is. Do they
Okay.
review that before they issue?
There's probably none of
Because it
us on
clearly
this
didn't
board
happen.
that know what the process is. I
Because
mean,
it-
we don't sit there and know what the administration of these building permits are.
In a perfect world, they're supposed to take all these things on a checklist and say, do I have all these pieces?
Then that
If they
piece was
don't have the
missing.
pieces, how can they say that there's not going to be a bad impact?
Right. So that piece was definitely missing.
Well, there's a checklist that they use, there's an application that they fill out. I don't have one in front of me.
So how is the code enforcement officer supposed to make a judgment on disposal of
He
runoff?
asked the applicant to produce a report from an engineer.
Well, I imagine he pulls out this book
Right.
amongst his other
Gotcha.
paperwork,
Okay.
and he goes through the checklist, the application, and he looks up, what does 175, 128 say?
I would, or is his motion still on the floor?
You'd like to what?
I would make a different motion, but do we need to?
Well, you've got a motion and a second.
Well,
I've asked Chuck if he
she's-
wants to withdraw it, and he hasn't at this point. So what is your question,
Well, wait a
Sabette?
minute, wait a minute. Let me clarify. She withdrew her second. I'll
Correct.
withdraw my motion. Go ahead.
I was going to make a motion that we uphold it. Given the way we've discussed that, this should have been part of the application process. This should have been done, a report should have been submitted as part of the process for the building permit. The code enforcement officer failed to review this and consider, either ask for an engineer's report or whatever would be necessary to determine whether runoff would be an issue. So I uphold this.
I'll second that if that's a motion.
Okay, roll call vote. All those in favor? Aye.
Aye.
Ryan? Sabette, yes. Sarah Silk, yes.
Yes.
Chuck, no. Kate?
Yes.
Yes. Motion passes. Only 3 more to go. Hold on. 175, 129, issuance of a permit. No building permit or certificate of occupancy shall be issued for the erection of a new building, the enlargement or increase in the floor area of an existing building, the development of a use not located in a building, or the change from one type of use to another unless off-street parking space or loading bays are provided in accordance with this article, 175, 129. I'd say along, along the lines of, we addressed that, and yes, that should have been done or been required. We said that on the other one.
So a motion to reaffirm? is
Reaffirm.
appropriate? Thank you.
Second. Roll call vote, Ryan, yes. Sabette, yes. Silk, yes.
Yes.
Chuck, yes.
Yes.
Kate, yes. 175, 136, off-street parking requirements. 2 spaces per dwelling unit may include indoor parking spaces serving individual units and may be stacked. And now, my recollection, I have none of whether they provided two additional spaces or not. Does anybody remember?
There was nothing present when the building official made his determination. That was on a drawing that we received at the hearing. Or, I think actually Mr. Brown, but. So how did you just word your last motion? You wanted to affirm that, reaffirm that this was not done?
Reaffirm from the last.
Okay. Okay. Make the motion to reaffirm that the off-street parking requirements were not addressed, not presented.
I second.
I'm not so sure that that wasn't,
It's not new.
where's that?
Don't forget, it's not whether it was present at the last hearing, it's whether this information was present when the building permit was issued.
Well, then we're not reaffirming, though.
That's a good point.
Yeah, it's not we're not reaffirming that. It wasn't on our findings of fact, on our previous decision.
Okay. Then I would reword the motion to say that it appears as if the off-street parking requirements were not addressed at the time the building permit was issued.
I second.
Roll call vote, Ryan, yes.
Yes.
Yes?
Yes.
Yes.
Okay, and the last one is 175, terms defined. Dwelling unit, one or more rooms arranged, designed or used for residential purposes for one household and containing independent sanitary and cooking facilities. And the B, the important one here, is a building and accessory thereto principally used, designed, or adapted with two dwelling units of similar proportion, the living quarters for each of which are completely separate. A single-family dwelling unit with an accessory dwelling unit is not a duplex dwelling unit. And I would accept a motion to reaffirm that.
Move to reaffirm.
Second?
Roll call vote, Ryan, yes.
Yes.
Yes?
Sabette, yes. Silk, yes. Chuck, yes.
Yes.
Kate, yes. So it appears that we've reaffirmed all of the 6 items that were in the application.
Well, we reaffirmed some of them, and the others we determined tonight, because not all of these were addressed before.
Okay. Does anyone keep track of what was reaffirmed and what was new tonight?
Yes. There's 6 items on the original application. 17589, we reaffirmed. 17591, we agreed. 175-128, C2, we agreed. 175-129, we reaffirmed.
Wait a minute. Reaffirmed at number 4.
Yeah.
Number 5, 175-136, we agreed. And 175-175, we reaffirmed.
Right.
Good job, Chuck.
Okay. Okay, so, I guess then I would need a motion to reverse the building department's decision and revoke the July 26, 2023 building permit number 20230000468, duplex dwelling owned by Mr. Beckwith Family Trust, as the construction, interpretation, and application of the terms of the zoning ordinance were in error.
So moved.
Wait a minute.
Second?
And findings of fact, I think we've got enough information that our attorney can assist us with the findings of fact. There's one last order of business, if I can find it.
We need to vote on this.
Oh, sorry. I made a motion. Do I have a second?
Yes.
I said so moved. You said second.
Second?
Second, Sabette. Roll call vote. Ryan, yes. Sabette, yes. Silk, yes.
Yes.
Chuck?
Yes.
Yes. Kate, yes. And then I would notice or state for the record that there is an appeal process for this, which I can't find the statute. I can't wait for there to be no case that involves you so that you can help.
Parties withstanding have 30 days to request a rehearing.
But that goes to Superior Court.
No, this is a separate one. This would be the same as when you voted on Brown. There was a request for a rehearing on Brown. So in order for an applicant to go to Superior Court or the Housing Appeals
that
Board,
was
they
the
first
other
have to
one.
request the
Yeah,
rehearing
okay.
here,
All right.
which you then entertain or don't entertain, and then it goes on from there.
So let the record show that this has a 30-day appeal period. I can't think of anything else that we may have missed. We've closed, I will close the public hearing,
Did that.
and I would then turn the meeting over to Ms. Klein for the remainder of the agenda, for which I am going to depart and go take some cold medicine.
Before you do you have any conflicts with the meeting calendar?
I'm not, whatever you guys do, I'll be here.
Okay.
Tavis, the meeting calendar was just monthly, right? Did it have the every 2
No,
weeks?
on the right-hand side, it had
Oh, I
the,
see, if needed. That's right.
Okay.
well, that was going to be one of my questions for the board. Do you want it as a standing meeting, or do you want to just call them as needed?
Okay, I'd like to address this because we've hashed this around before. And I looked and I checked the calendar, and I have an issue, as always, with the January date being bumped to the second Monday of the month because there are other meetings going on that second Monday. And I think it is poor form for us to stomp on their meeting dates when they respect our date. And I also looked at the chart, and work session was clearly if needed, and that's how we have been working, was if it was needed, we would add it. But we've always had a work session on the third Monday of the month, and when you check these dates, it's the fourth Monday of the month, which would mean that we would have a work session the fourth Monday of the month, and immediately the following week have a regular board meeting. And we had always in the past agreed that we would meet the first and the third. So I would just like to reaffirm that. We voted on it before for work sessions, and it was always the third Monday.
It also depends on when the room is available and what you're using it for. If you're using it for, the board has previously used the work session to do deliberations, findings of fact, et cetera, which is typically done with microphones in a larger room for public that can attend because there's a case assigned to it. If it's simply a workshop thing where everyone can sit in the annex conference room, that's fine.
There you go.
I think it's very difficult for this board to decide if it's going to meet. Functionally, you've only met twice, and this has been sort of a standing order for several months. So
Well, my preference is this on?
yes.
My preference is to have a standing meeting, have it on the calendar, on the website, and on our calendars, and if we decide for some reason we don't need it, or a number of people can't commit to that, then we cancel. But otherwise, we commit to doing the second meeting of the month.
So the easiest thing
The
to
third Monday, not the fourth Monday. I mean,
well, the trick with the
the
third.
third Thursday. It was the third Thursday that we picked.
Well, we did one or two because we had attorney meetings.
Those aren't meetings.
Well, whatever. We got
They're on our
together.
schedule.
You can't say
Yeah.
whatever because one needs a notice and one doesn't.
Technically, a
but-
meeting with attorney is a non-meeting, but let's just say we got together. How's that? But we,
It puts a placeholder in our schedules for whatever it is we need to do that is likely not a hearing, because we said we wouldn't take any new hearings.
So for
on those.
expediency, I can go through and mark the third Thursday on every date that's available for this room
okay. Well, just for your,
as a placeholder, and then as the meeting on the first Monday comes to a close, you'll have a better idea if you have something to work on and/or whether there's a conflict with the third Thursday.
Well, I would also like to put it in those days when there is something in this room, because we can meet in the conference room if we have some other business to attend to.
Yeah.
Is the library open Thursday night? We can meet
No.
in the library, too.
No.
No.
No, I have meetings on Thursday night for the Ag Commission, and,
Not the third Thursday, though, that's why we picked it.
no, not the third one, but the, they close at 5.
Okay,
Oh.
but we've got the conference.
But
Yeah.
they have a lot of meetings that go on there, but,
So the only reason I'm suggesting marking this room is because this, you need the space if you need it. If it goes to the annex, that's fine.
Yeah, we can reserve this room if it's available, but if not, let's have that meeting on our calendar anyway.
right. And can we all agree that it will be Monday, not Thursday?
I thought we had said Thursday because of your schedule.
Elections and 3-day weekends got weird with Mondays.
Yeah, 3-day weekends and elections, that's right. That's right, so I was looking at Thursdays,
Well, I looked
so,
down at my calendar today, and I looked up all the third Mondays, and I didn't see a problem with them. I can't imagine that we'd come, for instance, the fourth Monday of December, which is the 30th, which is like New Year's Eve.
no, we don't want
You
the
know,
4th.
so it would be February 19, March 18, April 15.
The 19th is President's
May 20th
Day.
is indeed the third one, and then June would be the 17th, July the 15th, August the 19th, September the 16th, October the 21st, November the 18th, and December the 16th.
Would you send that email to Terry, and we'll book those dates, and the board can modify as necessary?
Sure.
So February 19th is President's Day. Is the town hall open? No.
No. So maybe we skip that month.
Well, that's just it. You've been skipping them regularly, so.
Right.
March 18th.
Why aren't we trying the Thursday? Why did we dump
Because
Thursday?
Thursday doesn't work real well.
Oh. Okay, Monday doesn't work real well for me at all, but
I thought we had voted to put it on Thursday.
You did.
Okay, so Sarah's suggesting we change it to Monday.
But I didn't know it was a permanent change because we've always met before when we were trying to work on our rules of procedures on Mondays, unless we had a meeting with our attorney. I don't ever remember meeting consistently on a Thursday.
So what is your conflict on Thursdays? The third Thursdays?
First Thursday doesn't work for me.
Third Thursday.
It's easier for me to remember it on Monday if we always are consistent, I have to say.
Right, but Kate's not available on Mondays.
All right, well, whatever, if I
I
can
think
come.
that's one reason it's on Thursdays.
Technically, the third Thursday would have you meeting next week, if you'd like to meet.
Did it work for you I mean, honestly, I feel like the meeting should be set more based on what the members, the voting members of the board, not the what suits the alternates.
But Sarah says she doesn't have conflicts on the third Thursday.
Not the
You're
third,
okay.
no.
All right.
Well,
And that avoids the Monday thing, which I think is a good idea.
yeah.
And then
So we go to the
Cav has
third
just pointed
Thursday.
out that he's saying that that would mean we would have one,
Next Thursday.
right,
Or
because
not.
there's 5 Thursdays in November instead of 4.
Yeah,
And the fourth one is Thanksgiving.
yeah. So do
So
we
I
even
would
need-
schedule it for the 16th, and then we can decide whether or not we need to have it. I mean, that's
Well, if
a,
it's next week,
do we need to have it?
You're not done with the rules of procedure. I mean, we're only 2 years in.
Works for me.
Who said that? Chuck? Let's see.
We're talking Thursday, the 16th, right?
Correct.
yeah, I have my calendar with me.
I mean, I would like to work on things, so I'm going to say yes for me. And we were always saying 6 o'clock, right, rather than 7?
Can we do some of it, but can I join by Zoom?
I don't see why not.
Oh, that's a municipal association meeting Wednesday and Thursday.
Oh, the annual meeting?
Yeah,
15
going? I'm
15
not.
and 16 is NHMA, yeah. You
Yeah.
guys can meet whenever you want. You don't need staff.
Right.
I knew that rang a bell. I won't be back by 6.
Well, I can join by Zoom whenever.
Okay, who would like to meet next Thursday and work on rules of procedure? I'm a yes.
No.
I'm okay.
Luke?
Yes, whenever.
Okay. What? Yes, no?
Yes, whenever. I'm
Okay.
flexible.
All right, so
Can you
that's a
let them
yes.
Yes, I can let them in.
So,
Start the recorder.
yeah. Please send out email to
Yeah.
the board, because Sue's not here.
Since I've acquiesced to your Thursdays, how about we just change that January 1 to the 15th instead of the 8th, which is a conflict with another board?
I think that would be okay.
Thank you.
January
Change
what?
The January,
15th.
That's Martin Luther King Day, so good luck with that.
oh, yeah,
Oh, they're not
that's a
here.
holiday, right.
Yeah.
I don't see really another day to be able to do that.
So we're meeting next Thursday.
The third Thursday's 18th.
Next Thursday.
Thursday, the 16th.
It's 6
p.m.
Yeah, okay, good.
What's the 17th?
January 17th would be a Wednesday, right?
What?
January 17th would be a Wednesday.
January 17th is a Wednesday.
Okay.
Selectmen's-
Any communications or miscellaneous?
What did we decide on for January?
Didn't,
We're going to leave it on the Thursday.
Okay.
so everything's going to the third
Wait a
Monday
minute,
except
I'm
for
lost here.
November?
Third
And
Thursday.
January? Now we're going to the third Thursday? Okay.
Okay, so it's going
For
to
all of them? For all of them,
Yes,
henceforth?
be,
right.
okay, third
On the
Thursday,
schedule. Can you put it on the calendar, too?
starting
It's
with
going to be on
November
that schedule, it'll be
16th.
on the calendar, yes.
I'm sorry, what?
That's the third Thursday, starting with November 16th. And what was the end date for the January meeting?
There is no.
18th.
Say what?
1/8.
Oh, okay.
Yep,
All right.
18.
I thought I heard somebody say they were changing it to Thursday.
Leaving that.
She did.
We are changing it to, they're all
Pain
Thursday.
in the ass.
Do you know when the election, local election is yet?
Not a Thursday.
Second Tuesday in March.
I'm going to guess it's around the 12th or the 12th
They
is the
still don't have a
Tuesday.
date for January.
Oh,
Thought we just said the 18th.
We can just set it for the third Thursday at 6 o'clock,
yeah,
and
Third
then
Thursday
I'll
at
double
6.
check those dates and put it in an email if there's a conflict.
okay.
Okay. What do I do with my agenda?
Is there any communications or miscellaneous that I'm
Just-
not aware of?
You didn't meet Sierra? Sierra's the new?
Yes, we did.
Okay.
Hello, our new recording secretary. Nice to have you with us.
Oh, this just in from upstairs. If you do anything on a Thursday, the TV crew can't be here.
Okay.
So if you continue a public hearing to that meeting, there won't be.
Yeah, no, we're not going to do that.
Okay, well, that's kind of how it originally started, but then,
That's right.
Yeah.
Now I remember. Yeah.
I guess that's why we didn't pick Thursday before.
Kate asked a question, and I have the same question. Is there a meeting in December, or are we going to not meet the third Thursday in December?
there are no applications received as of today, so there wouldn't be one regularly unless you want to have a work session.
So, yeah, that would be 21st, and that's, you're asking because it's right before Christmas? I mean, we schedule it, it's on the 21st of December is the schedule. Well, and at that point,
All right.
we can decide whether everybody wants to come or not.
Okay, so
Well,
is
well,
it positive we're not having the first Monday?
The first question is if you don't have an application pending, and I'm not aware of receiving one today, you have no reason to meet on the 4th. You could use the 4th as your work session for
True.
December.
Yep.
Oh, that's a good solution.
Let's, what is the deadline for the apps for the 4th?
4 o'clock today I'm not
So there-
aware of one.
Okay. So there's a good chance that we will do a work session on the 4th and not meet on the 21st.
A good chance. Is that a definite or a maybe?
I will affirm that in the morning. I was in a meeting from 1 to 4. I don't know if something came in. I'll have to check.
Right, pending any applications that might come in. Okay,
Sounds good to me.
I like it.
I'll try and get all of that clarified in an email.
So with regard to Zoom, what is our technical ability to Zoom? I mean, I could bring my own laptop in Zoom, or I could like Zoom on my phone, but is there anything the town does on a regular basis for IT for Zooming?
The only thing I'm aware of is the selectmen have a Zoom link. It's not Zoom, it's GoToMeeting. We can create a GoToMeeting.
I think
But don't
Zoom is better.
we have to have the TV people here for that?
Yeah, well, if
And
you
we can't
want to
do
know
that?
all the...
on Thursday, we don't have the TV anyway.
If you want to know all the technical details, yes, there's somebody down here with a laptop that's plugged into Zoom. There's a laptop that's plugged into the projector so that you can see it, and TV takes the feed off of that. You wanted all that detail.
Could
but
you
yes.
explain that again slower? So they have a,
If we have GoToMeeting, if a board decides it's going to have GoToMeeting, there'll be a laptop down here, and it'll be visible on the screen, and it also works with TV.
so it's visible on the screen,
Yes.
okay.
But all it is all you see on the screen is what's on TV. So if you're talking right now, Magic Man will point the camera at you, and you'll see primarily Audrey on the screen. Comes back to the whole board. If somebody online is
So you're
talking,
not looking at the GoToMeeting interface like on your computer,
you would if you logged in from your chair,
but
yes.
not up there, yeah.
Correct.
So is there a laptop that we can use and set up so that the person, so we have a GoToMeeting screen that we can all see?
If the board wants to go through the GoToMeeting remote person protocols for every meeting, you
Honestly,
can do
I'd rather do Zoom, but,
that. Oh, me too. I'd rather be home doing this than sitting here, but.
no, I mean, I'd rather use Zoom than GoToMeeting. Do you guys,
No, we
you probably
don't.
do everything. Yeah.
I don't believe the town, I
You'll-
don't,
Zoom is a lot better.
Zoom is so easy.
We use,
The-
at my meeting tomorrow, we use the hybrid. We have that owl camera, so that's half of us are in person and the other half are remote, like in Seattle and stuff.
Right.
And so the camera,
I'll have to look into it. I think the town has a GoToMeeting account. It doesn't have a Zoom account. It turns into how many meetings you have and how many participants and all that sort of thing. I know
So,
the actual IT company is
Yeah.
encouraging the town to go to Microsoft meetings.
That's a
opposed-
nightmare. So is there any problem
Everyone has an
with us
opinion.
using Zoom just because we can use it for free and have an account? I mean, do we have to go through a town account?
I think if a town board is going to use an account, it needs an account.
Okay,
I will check and get back to the board.
right. I think the town can get a free Zoom account as long as it's under 50 people or something, which is, you know,
Most, but not all meetings,
You
right?
can get some free Zoom account things as long as you don't go over, like, 50 minutes or something, if it's a
That's true,
short one.
too.
Because a lot
Yeah.
of
Well, good
people
luck with
use
that.
them to get family together, and they don't have to pay for the Zoom account as long as they don't exceed that amount of time, so.
We'll have incentive to close our meetings in less than 50 minutes. I like
But the town should be paying for, somebody should be paying for the meeting that can go longer than 50 minutes.
Well, they have GoToMeeting.
Oh, is that what they have? So
they have go-to meetings, but,
It's kind of,
it's a pain in the butt. Better meeting's harder.
all right, so I guess, are we,
I'll pay for it. What is it? What does it cost? If you want an annual.
would anybody like to make a motion to adjourn?
Oh,
Yes.
please.
yes.
So moved.
And
Second.
seconded?
Yes.
Okay, so Chuck and Sarah,
yep.
all in favor? Aye.
Aye.
Thank you.
Like an old dog right now.
Oh,